The judge has already denied David Stebbins' request for counsel and other things. Let's take a look at what the judge has to say. This was just released on January 3rd. Before the court is Plaintiff David Stebbins' motion to appoint counsel for the response to the court's order to show cause. That was the order to show cause why he should not be sanctioned $1,500 for lying about not receiving PayPal fees. He required the defendant, Mr. Imperialsalt, to pay the PayPal fees, and then it appears that he actually wasn't being charged PayPal fees the whole time. So I don't know which is true, but he has to show cause. So he has to show up to court. Was December 30th. Now it's January 30th. You'll see. And he has to show up to court, and he has to explain what happened with the PayPal fees, and he might be sanctioned $1,500. And he made a motion for an extension of time to respond to the order to show cause, so he wants even more time than January 30th. For the following reasons, the court denies the motions. On December 13th, the magistrate judge ordered Stebbins to show cause in writing why he should not be sanctioned $1,500 for filing a motion with the court based on false claims. Specifically, the court asked Stebbins to show cause why he did not falsely state, quote, that PayPal had deducted fees from defendants' monthly settlement payments when PayPal had in fact not deducted any fees. Stebbins objected to the magistrate judge's order and filed a motion to extend the time to respond to the order to show cause until the district court ruled on the objection. The magistrate judge granted Stebbins' request for an extension of time and set a new deadline of January 30th, 2025, for Stebbins to respond. The court then affirmed the magistrate judge's prior ruling and extension of time to respond. This is a thing with the federal courts. You can have a magistrate judge rule, and then the actual judge in your case has to confirm that ruling. Stebbins subsequently filed a motion to appoint counsel for his response to the order to show cause and another motion for an extension of time until the motion to appoint counsel is ruled on. So, in the Ninth Circuit, a court of appeals, so that district or that circuit, district courts have the discretion to designate counsel to represent an indigent civil litigant. Counsel may be designated under 28 U.S.C. Section 1915 E1 for indigent civil litigants where there are exceptional circumstances. And we've seen this law before. This law allows the judge to review the application for indigent status or in forma pauperis status. And once this application is made, the judge can actually dismiss the case early if they think that it's frivolous. So this is a way to prevent people like Stebbins from filing frivolous claims in cases. He survived it in this case because, as you saw, it seemed like he had some kind of meritorious claim against Commander Imperialsalt, so the judge let it go forward. In determining whether exceptional circumstances exist, courts evaluate both the likelihood of success on the merits as well as the ability of the petitioner to articulate his claims pro se in light of the complexity of the legal issues involved. So, is he likely to succeed, and is he able to articulate himself despite the complexity of the issues? Courts are instructed to consider both factors together before reaching a decision. On Rule 11 sanctions, this is Federal Rule of Civil Procedure 11, sanctions may be imposed when a filing is frivolous, legally unreasonable, or without factual foundation, or is brought for an improper purpose. The court's local rules further provide that the presentation to the courts of frivolous motions subjects the offender, at the discretion of the court, to sanctions. Whether to impose sanctions is a matter within the court's discretion. The Ninth Circuit has cautioned that Rule 11 is an extraordinary remedy, one to be exercised with extreme caution. When sanctions are imposed, they must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. The court in this case must first decide whether the proposed sanctions are criminal or civil in nature. Stebbins claims that he is entitled to counsel because, under Hicks, the sanctions are punitive and therefore criminal. This is an important distinction in American law. Criminal cases have a heightened level of due process, and civil cases have a lower level of due process. So when you get sanctioned in court, what the punishment is or what the nature of the sanction is and whether it qualifies as civil or criminal matters to what defense you're going to be able to make and whether counsel needs to be appointed under the Fifth Amendment or other counsel appointing statute, and what standard of proof is going to be used. According to Hicks, if the relief provided is a fine, it is remedial when it is paid to the complainant and punitive when it is paid to the court, though a fine that would be payable to the court is also remedial when the defendant can avoid paying the fine simply by performing the affirmative act required by the court's order. So at first glance, that looks like you would need to use the punitive or criminal level of protection, of due process protection. But the court goes on. Because the proposed sanction would presumably be paid to the court, Stebbins claims the fine is punitive in nature. Further, Stebbins is unable to avoid this sanction unless he can show cause as to why the sanction is not proper in the first place. Thus, Stebbins claims that this order to show cause is akin to a criminal proceeding and he is constitutionally entitled to counsel. This is a good argument. This is not a bad argument. It doesn't work, but it's not a bad argument. The court disagrees with Stebbins and finds that the proposed sanctions are civil in nature. First, Hicks is not dispositive. The Ninth Circuit has held that whether a fine is payable to the court as opposed to the complainant is relevant, but not determinative in determining whether a sanction is punitive. In other words, you can use other factors too. Further, the Ninth Circuit has recognized that the court in Hicks did not contemplate a situation regarding sanctions for bad faith conduct, where the court to which the fine was ordered to be paid was, in effect, the injured complainant. Direct contempts that occur in the court's presence may be immediately adjudged and sanctioned summarily, and except for serious criminal contempts in which a jury trial is required, the traditional distinction between civil and criminal contempt proceedings does not pertain. Here, Stebbins faces sanctions for potential false statements made directly to the court. Thus, the fact that Stebbins may be ordered to pay sanctions to the court does not necessitate a finding that such sanctions are criminal under Hicks. Second, the court notes that Stebbins can avoid the potential sanctions if he proves that he did not make false statements to the court in violation of Rule 11. Thus, unless Stebbins lied to the court, he may avoid paying the sanctions if he properly complies with the court's order to show cause. Finally, the court looks to the purpose of Rule 11 sanctions. Sanctions imposed under Rule 11 must be limited to what suffices to deter repetition of the conduct, or comparable conduct by others similarly situated. Thus, assuming that the magistrate judge intends to impose a sanction that is limited to deterrence under Rule 11, it is unlikely that such a sanction will be punitive. Consequently, the court finds that the possible sanctions are civil in nature. Stebbins is therefore only entitled to notice and an opportunity to be heard before the imposition of sanctions. The request for counsel. Because the potential sanctions are civil, the court must next consider whether it is proper to appoint counsel under 1915. Exceptional circumstances do not exist to warrant the appointment of counsel. Stebbins' likelihood of success on the merits is uncertain. He can successfully avoid sanctions if he proves that he did not falsely claim that PayPal deducted fees. However, the court previously found that Stebbins must have seen that PayPal did not deduct any fees. Therefore, there is a chance that Stebbins may not succeed on the merits. However, Stebbins has proven to the court his ability to articulate his claims pro se in light of the complexity of the legal issues involved. First, Stebbins demonstrated his ability to articulate his claims in various prior motions filed with this court and in his current motion to appoint counsel. Specifically, Stebbins cited relevant persuasive authority in his motion, which is considered by the court in its decision. Second, the court has asked Stebbins to show cause why his own statements were not false. This is not a complex legal issue for which attorneys are required. Indeed, it is a factual issue where Stebbins is likely the best person to respond. Consequently, weighing this factor alongside Stebbins' likelihood of success, the court finds that the potential sanctions are not an exceptional circumstance warranting the appointment of counsel. Thus, the motion to appoint counsel is denied. More time. Stebbins has also filed a motion for an extension of time to respond to the order to show cause until the motion to appoint counsel is ruled on. Because the court now denies the motion to appoint counsel, it does not find that Stebbins requires an extension of time to respond. The magistrate judge originally gave Stebbins until December 30th, which was 17 days. The time to respond was then extended to January 30th, giving Stebbins 27 more days from the date of this order to respond. The court does not find it necessary to grant Stebbins any additional time, thus the motion is denied. The court denies both motions for appointment of counsel and for an extension of time. So ordered, says the judge. This is Judge James Selna. It's not signed, so I'm assuming that's who's writing this, is the person whose name is on the caption. So yeah, that's where we are with the latest Acerthorn shenaniganery. Stebbins may be snatching defeat from the jaws of victory, having won $1,800 and now having to pay $1,500 of it to the court as punishment for the lying to the court about the PayPal fees, if in fact he did. We'll wait to see what the judge's ruling is on that. Let me know what you think in the comments below. This is also kind of an educational opportunity for why you need an attorney and why you need legal training to navigate the American legal system, which I do not agree with as like a societal aspiration that we should be requiring citizens to be lawyers in order to understand their legal rights, or requiring citizens to pay hundreds of dollars to lawyers in order to understand their basic legal rights. There should be some mechanism where which people get basic legal representation, so it's not always David and Goliath in every case. But this is why you get an attorney, because you can see that he's able to make some arguments, but then not able to handle the pitfalls that he falls into, the holes that he falls into, completely understandably. Like, I'm not trying to make fun of the guy. The situation, yeah, I'm making fun of the situation. That it's petty. It's not necessary to put this much effort into something more productive. It's just the cold hard truth of it. I'm not saying that anyone's a great actor in this situation either, but this is a very clear example of why even a pro se litigant who is successful at articulating themselves in the law still falls afoul of it. Me, as a practicing licensed insured attorney, I still make sure everything is dotted, T's crossed. You know what I'm talking about. Go through some kind of a checklist. Did I check the federal rules of civil procedure? Did I check the federal rules of evidence? Did I check the court's procedure? Did I check the judge's procedure? Were there any standing orders that I missed? It's unbelievable how much you have to check to file one document in federal court. I think the last time I checked, there were 7 sets of rules. Oh, yes, and am I within my rules of professional conduct as well is another one. There's a set of redaction rules for when you have to redact personal information out of things. So it is unbelievable how complicated it is to represent yourself in federal court. It should not be that complicated, and I do agree that people like Stebbins, really anybody, should have some kind of basic representation, even in civil court. But who's going to pay for that? I don't know. Anyway, let me know what you think of those ideas in the comments below.